Nothing competes with us.
Good afternoon, everyone. Thank you for joining us for Constitution Day. Today is the day that commemorates the signing of the U.S. Constitution on September 17th, 1787. It reminds us of the fundamental principles of democracy, liberty, and justice that continue to be polarizing issues today. In a couple of minutes, Professor Kevin King will start by asking questions that have been gathered from students, faculty, and staff. If you have additional questions that you'd like to contribute, please write them on a 3x5 card and drop them in the box at the back table. For those joining us via Zoom, please feel free to submit your responses and questions in the Q&A section. We'll review all the questions and begin addressing them in about 30 minutes. Now please welcome Dr. Matt Jones and Professor Kevin King.
Thank you.
Where are you pushing that? Where do you push? Is it on?
Oh, it's just on.
It is.
So good afternoon. Do you have any comments?
No. So, let's go.
So we took a look at these questions, and the first way we're going to start is kind of categorizing them a little bit. So the first grouping that we have is really kind of structural questions about the Constitution. So we will begin with that. Ready? How should the Constitution be interpreted? Strictly according to the original intent of the framers, or as a living document that evolves with societal changes? What are the implications of each approach on modern governance?
Okay, I didn't see this question. Is this new? I feel like I'm being ambushed. So, okay, this is a very nerdy question. And so how should the Constitution be interpreted? So there's these two kind of concepts. It's original intent or as a living document. This gets most of the literature on the Supreme Court and Constitution is arguments over these two things. And I'm not going to take a side here on this, but there are implications for you. So essentially the question is how much, when the Supreme Court tries to interpret the Constitution, how much should they be really flexible with their interpretation? Because the English language is crazy flexible. So what one word means can be interpreted in many ways. As a matter of fact, I think with my American history class, we talked about that yesterday, right? How the language could be interpreted differently. I could try and compliment my wife by telling her she gained weight in her thighs, and she could see that not as a compliment, but as an insult. You know, and it's like, that's because language is so flexible, to what extent should justices or judges over 200 years after the Constitution was written kind of read the words and try and use the words of the Constitution to mean whatever the judges need them to mean to do justice? That's the concept of a living document. Concept of a living document is that when we wrote the Constitution, well, when the framers wrote the Constitution, they established these general principles. So the classic example is the Eighth Amendment. No government, whether federal, national, or state government, can institute cruel and unusual punishment. Well, that's very broad. What's cruel? What's unusual? What I consider to be cruel and unusual, you might consider to be, I don't know, the best concert you've ever attended. So, and that frequently happens, right? You know, you guys frequently go to Taylor Swift. I consider it cruel and unusual punishment. So, but in terms of the actual words, cruel and unusual, at the time it was written, there were still public floggings, there were still whippings, there were still public hangings, but now we consider all of these things cruel and unusual. So the language itself is very flexible. Should the Supreme Court be able to kind of just take language and say, well, it might have meant this 200 years ago, but we can interpret it to mean this now, and we believe that this is better for justice. Does that make sense? Yes? The other side, which is original intent, it says that What was the original intent of the words when they were written? That is what we have to go by, because law has to have a set meaning, otherwise it becomes too flexible and it doesn't become law. And more importantly, the side that says it's not a living document says that we have to go by the original intent, to the extent that we can understand it, of the Constitution, otherwise we lose democracy. Let me explain. We have 9 justices of the Supreme Court. They are not elected, and they serve for life. They can't be fired easily, and their pay can never be reduced. So they have tenure. As somebody who has tenure, it's good. Tenure is good. It allows you to be offensive and not get fired. But tenure is good, but the thing is they aren't elected. So if they get to interpret the Constitution any way they want to, are we really a democracy? Or are 9 unelected old people essentially deciding all the big important questions of our political system? And so the original intent people say, only the original intent of the words, that's the only way we can interpret it. All in, so that 9 justices don't become essentially the king or the oligarchy of our system. Does that make sense? So that's the divide there.
So outside of the original language that's in the Constitution, where are we gathering the original intents from?
That's a good question. So fortunately, the framers of the Constitution wrote a lot, I think because they didn't have social media. So, and they were constantly writing and debating. We have letters from Madison, Hamilton, George Washington. Adams is writing like crazy. He wrote so freaking much. So Thomas Jefferson, of course, has a diary because he was that kind of guy. So we have a lot of their writings, which help. But we also have kind of the common use of the words that we still have going on today. There's another side of original intent that says it's not the words that how they were, they specifically, the author who wrote them was intending, but what was the most plain meaning of the words? And the plain meaning, not the meanings that you could interpret it, but what was the plain meaning of the words? And that these are what we have to go by. But the challenge of the living document, people, is part the challenge of how do you know what that original intent is?
But would we not argue that this is still a living document with our amendment process?
Isn't that one of the questions?
I think we do get into that there.
So let's put it
Okay,
there.
let's hold that one. Okay, next question. Is it possible for a sitting president to change the Constitution from 2 terms to more or unlimited re-elections?
Okay, so I don't know who actually submitted this question. I think it was an anonymous student, and I think we can, for the intents and purposes of this discussion, call this the "but Trump" question. Most likely the student who submitted is like, but what if Trump gets into office and, you know, blah, blah, blah. What if Trump gets into office and we have to look at his terrible hair for 4 more years, blah, blah, blah. This is the but Trump question, right? So, and we don't have to worry about that for this key reason. The president has no process in the amendment process whatsoever. He has no power, no voice, no decision making. The way you add an amendment to the Constitution is that 2/3, it has to be proposed. It has to be proposed by a member of Congress, of the House of Representatives or the Senate. And then 2/3 of both chambers, 2/3 of the House of Representatives and 2/3 of the Senate have to vote to approve it. Now, it doesn't go to the president at all. It goes from Congress to the states, and 3/4 of the states have to then ratify it, either through their state legislatures or something called a convention. The president has no voice. He could propose. He could go to Congress and be like, hey, wouldn't it be great if I could serve unlimited terms? That's kind of what FDR, he didn't go to Congress, but he kind of said, wouldn't it be great if you had more of me? And the American people kind of said, yes, it would, and this is why we get the amendment that limits it to 2 terms. But if we were going to get rid of that amendment, Congress in the states, the president has no power, unless he persuades Congress in the states.
During the framing of the Constitution, What were the arguments for and against term limits of presidents?
Oh, that's a great question. Hey, you're really good at this. You should probably teach history. So, that's a great question. So the arguments for and against. So the arguments for term limits were pretty obvious. You kind of get somebody who's gaining too much power and you get them out so they don't start to become a king. You know, because who wants to become president? Like, if you think about the population of people who kind of look at and they say, hey, I want to do this thing where I'm working 80 hours a week on a campaign. Every skeleton in my closet, every kind of thing that my family's done wrong, my wife's mental health issues, all of them are going to be looked at and tried to bring out in public in the media. If you look at all of this, you say, sign me up for that, so that then I can make life and death decisions over other people's lives and get aged 16 years if I serve 8 years in office. Who's the type of people who actually want to do that? Only the most arrogant, egotistical, and ambitious people among us are going to sign up for that,
The
right?
most virtuous.
That was supposed to be the idea, but like only the ambitious and arrogant are going to sign up for that. So, I mean, that's why it kind of sounds good to me. So, but so the idea of term limits is if you've got these arrogant and ambitious people who are president, you need to limit the amount of power that they can acquire over time so that they don't try and make themselves king, so they don't become Caesar, who goes from essentially senator general to emperor of Rome. It's the kind of the prevent Caesar from happening concept. However, Madison, James Madison, who's considered the father of the Constitution, and Hamilton, they both said term limits are terrible. Term limits are terrible because it's anti-democratic. You limit the choices of the voters as to who they want to be their representatives. You artificially say, no, you can't choose this person. So, and I get why you're doing it, but you're saying, no, you can't choose this person. The other reason they believed that term limits were bad is because they believed that you wanted to have experienced people in office, and that virtue thing, that there's only a few people who are ambitious and virtuous at the same time. Once you find them, you don't want to term limit them out. You want them to continue in office. The idea of elections, in part, is trial and error. That's what they believe, that it's trial and error. You put somebody in office and you go, nah, kind of sucks, you know. Put somebody else in office and you're like, they don't suck as much. Let's keep going with that person, as opposed to term limiting them out and we have more trial and error, more trial and error, more trial and error. So those are the two arguments for it.
Yeah, and I'd like to talk a little bit more about the virtue aspect of it for the kind of people that they were at this time period. But we have other areas in these questions that I can put that into it. So for the next question, and I really like this question, why is it a bragging point that we have never outright changed or updated the source material of the Constitution, but every other country on earth, with one consistently updates theirs to match the needs of the people? Is stagnation good, or does it breed mosquitoes?
I see somebody tried to be a poet at the end. So, yeah, this is a fair question. So we have, of course, we have 26 amendments, and India, for example, has 106 amendments to its constitution. Germany has 60 amendments to its constitution. Both of their constitutions were, Germany's constitution was established in 1949. We essentially shepherded them into it because they lost the war and we won, so America. And so that's the second German constitution, by the way, that the Americans gave Germany. They also gave them their first constitution, their democratic constitution after World War I, which elected Hitler, so maybe our track record isn't great. But, and India's constitution was formed in 1950. So both of them are less than 80 years old, and they have, you know, double the amount of amendments or quadruple the amount of amendments we do. Is that a good thing or a bad thing? That's the question, right? So obviously the reason why they have more amendments is because their amendment process is easier. Now both of them have two-thirds of both chambers. So in India, both two-thirds of the Lok Sabha both chambers of the Lok Sabha have to have to approve of it. And then 2/3 of the Bundestag and the Bundesrat, the lower chamber and the upper chamber of the German parliament, have to approve of it. But there's no states. No states have to get involved. So it makes it easier to do, right? 2/3, that's it. Is that a good thing or a bad thing? Kind of all depends. What I will say is that I will take a position on this. I think that our Constitution having few amendments is actually a good thing. The reason why it's a good thing is because, one, it's based off of our history. The difference between us and Germany and India is Germany and India were late democracies that came because of decolonization or World War II. They had a lot to figure out, so they needed changes. They're brand new democracies, right? And when you're a brand new democracy, you create a constitution, and then as you have to actually live under that constitution, you make some changes. Whereas we aren't a brand new democracy. So even when we were a revolution, as Edmund Burke puts it, we were a conservative revolution. We already had a way of life that was 100 years old, and we revolted from the British to keep the way of life that we were already living. Right? The British came in and were disrupting what the American colonies were already doing. The American colonies were governing themselves. They had created their own systems of government, self-government. And then the British come in and say, hey, we want some money because of this empire's too big. And we, of course, as Americans say, you want to tax us? Get out, right? But we were already living under forms of representative government for generations before the Revolutionary War. So when we put in our Constitution, we were putting in a Constitution that was based off of a Republican form of government, small r, Republican form of government, that we had already been experimenting with 13 colonies for generations. Whereas Germany and India, it's brand new. And so, and they're adopting, like Germany is adopting like British and American constitutions and then having to figure out how to make sure it works for Germans, because Germans are different people than the British or Americans, right? We know that. Like, Germans are better at making cars, they're better at keeping time, they're better at doing a lot of things, right? They're worse at not starting world wars, but they're better at a lot of things. So, but in India, just had British constitution. And so, and that's, I mean, that's a European constitution. So they've had to like figure it out as they go along. We did not. That makes it. Oh, also the other thing is we're a federal system, which meant a lot of the experimentation and how we do government happens in the states. Right. So that's why California has been like such a radical experiment in so many ways, whereas other places are much more conservative, like Utah, which relishes in being, well, a lot of states these days relish in being not California in the sense of let you guys do the radical experimentation and we will just wait and see what happens.
And I would just offer a much simpler explanation of why I think it's an ultimate flex is just the fact of where the ideas come from. Where do we say our rights come from? They're not given to us by a government. They're given to us by our creator, right? So I think that kind of is a major flex in the sense that they don't need to be changed because it's not based on what a government is allowing us.
So let's take that and secularize it for a second. Instead of saying creator.
I did that on purpose.
I know you did it on purpose and I appreciate that, but like it's natural law or universal law. The idea that you know, just like the laws of physics and the laws of biology, the laws of morality are universal, and therefore the rights of humanity come from essentially being human, and regardless of anything else. But yes, and that leads to the last thing. The problem with amendments is that they can be pretty radical, and radical politics is always dangerous. Radical politics is the 18th Amendment, right? I've got an idea. Prohibition. We look around and does alcohol cause a massive amount of problems in our society? Absolutely. By far, probably one of the things that causes the most problems in our society is alcohol, right? I would say like maybe sex, but most of that happens because of alcohol anyways. So alcohol is probably the large thing. And the progressive reformers who wanted to kind of get rid of alcohol for a good reason, right? Because they see a whole bunch of men who come home, who don't come home from work, but go to the bar or the pub from work, get drunk and come home and beat their children, or spend the money to educate their children on alcohol, or, essentially become dangerous at work because they're still hungover and drunk and working around heavy machinery and causing accidents, and they say, see this source? But the problem is it's radical. You can't impose sobriety just on a society because you look at it and say, it would be better for you. I see the way you live your life, and I have a better vision for the way you should live your life than you do. Let me use the Constitution to impose my vision for your life on you.
They were the guardians of moral fiber.
Right, it just doesn't work, right? Especially, and I could say this because my ancestors were Irish, if you import a bunch of Irish people in and then ban whiskey, it's just not going to work. And so we see this all the time. We see this with the war on drugs. Right? I have a better way for you to live life, and it involves you not, right, doing lines of coke and then trying to go to work. And all of those things are like, yeah, the world would be a better place without alcohol. And I say this as somebody wearing socks with whiskey glasses on them, right? So, but it doesn't mean that you can do radical politics and force everybody else from a top-down constitution to the people model to change their way of life because you passed an amendment. It fails.
But it's also a testament to our ability to correct course in repealing that legislation.
Absolutely, of course. But in the process, before we repealed it, we got the rise of mafia, Al Capone, speakeasies, NASCAR, like one of the worst things to come out of Prohibition. So, like a lot of things. So, I'm sorry, I have to be ridiculous. It's just who I am.
Are we moving through these quick enough, Tyson?
So far, no questions from the audience that I can see.
Okay.
Unless anybody has any questions. They have not delivered.
Oh.
All right, next question, moving on. How does the Constitution navigate the tension between federal authorities and states' rights? In what ways has this relationship evolved, and what challenges does it pose in addressing contemporary issues such as healthcare, education, and civil rights?
All right, so this question is actually very, very good, but a little boring and less relevant to the students, so I'm going to change it just a second. I'm going to make it relevant to you and so that you guys will perk up and pay attention by talking about weed instead. So, what? It's true, right? So, sorry I'm wrong for thinking you're all potheads. So, all right, so there's federalism when it comes to pot, because marijuana is still a class 3 controlled substance under the Federal Controlled Substances Act, which means it is still illegal to grow, distribute, sell, or even possess significant quantities of marijuana everywhere in the United States under federal law. But California changed its law a few years ago just because, to get with the times, I suppose. And California said, you know what? Under California law, it's no longer illegal. Now, that wasn't a radical change because most police officers weren't enforcing the law anyways, because it was just not worth enforcing at the time. There were so many people doing it and it was a lot of paperwork to put people who were otherwise had no criminal records into the system, and in which they would most likely get 0 jail time whatsoever and keep doing it anyways. And then eventually when we did medical marijuana, you could get essentially a green card, a medical marijuana license for almost anything. Like, I had a headache 5 years ago. Oh, well, you know what, marijuana could help with that, right? So kind of the opioid crisis today. But at any rate, so California changed its law. So it is both legal and illegal in California to possess marijuana. And so yet we have dispensaries. As a matter of fact, I believe, correct me if I'm wrong, Tyson, but I believe this college makes money off of marijuana in Kern County. So I guess it's good you're all potheads. But so at any rate, no, just say no. But at any rate, so how does that work? Well, what it does is, essentially what happens is, the Supreme Court has ruled that the federal government cannot force, please get this, cannot force states to enforce federal law. So if the federal law says it's illegal, then federal law enforcement has to enforce it. Unless the state agrees to enforce it for the federal government by making its own law saying that it's illegal. And usually the state will do that either because they also believe it should be illegal or because the federal government gives them a grant to do it. So when California passed its Make Marijuana Legal law through the proposition process, essentially what it said is, if you want to enforce the Federal Controlled Substances Act, you have to do it through the FBI and the Attorney General's office. And so when Colorado and California, I think was the first to kind of become a pothead state. So when Colorado did that, the Attorney General at the time, John Ashcroft, organized this massive kind of raid on all of these dispensaries to try and remind everybody that, hey, it's still illegal. But because 9/11 had happened and we were in the middle of the war on terror, it created this massive political problem for the George W. Bush administration, where they said, don't you have better things to do than arrest potheads? They're terrorists that you should be focusing on instead. And that was the last time the Attorney General's office ever tried to do a significant raid on dispensaries. And so any dispensary that exists in California, Colorado, Oregon, Washington, those places, at any time the federal government could come and raid them, you're just counting on that not happening.
So what leverage might the federal government be able to exercise over a state if they really felt compelled? And what issue do you think might drive something like that?
Well, I mean, besides money, so under the necessary and proper clause of Article 1, Section 8 of the Constitution, the federal government can give money to any state for any reason to kind of bribe the state into doing what the federal government wants. That's how we got No Child Left Behind. That's how we got Common Core. That's how we got the war on drugs. That's how we have almost every city in California has an anti-terrorism task force. That's how we get all of these things. That's also how we got the interstate highway system, by the way. So, is the federal government can essentially, now that combined with the 16th Amendment, which has allowed the federal government to do income tax. So now what the federal government can do is it does an income tax where it says, we're going to take most of your citizens, we'll say California, we're going to take most of your citizens' income, California, so that you have to shrink your income tax so that you don't pressure your citizens too much. And then we're going to take that money and we're going to say, hey, do you want some of it back? Then we'll give it to you as a grant, but only if you implement No Child Left Behind or Common Core. So, and then that's the way that they bribe us into taking money. Now, California or any other state can say, we're not going to implement No Child Left Behind. But of course, the Department of Education, which by the way, the only job of the Department of Education is distribute money and then to say, do what we say because we gave you money. That's the only reason the Department of Education exists, is grant money. Because under the 10th Amendment, education is a reserve power of the states. The federal government has no direct authority over education whatsoever. It has to bribe the states to do anything. And so, but it does bribe us, and the states are, I was going to use a word that I shouldn't use, so I'm going to use a different word. I'm trying to think of a non-offensive, greedy. Greedy is a good word, okay. The states are greedy, right? They want that money. So the only state to say no to Common Core, for example, is Louisiana, and they do not get federal funding because they said no to Common Core.
It shows.
Huh?
And it shows.
Well, Louisiana has a big problem anyways, because Louisiana was the most corrupt state in the Union for the 20th century because of Senator Huey Long.
Didn't Louisiana also resist the driver's license age, or the, was it driver's license age? That's with the roads, with the highways, I can't remember exactly which one it was, but they were another resistance.
So the reason, for example, the reason why there was a 55-mile-an-hour speed limit for the longest time is because the federal government said, if you want any money for your roads, to maintain your interstate highways, you have to have a 55-mile-an-hour speed limit. And then in the late 1980s, that went away. And they said, you can still get the money without having a 55-mile-an-hour speed limit. So California went to 65, and then Montana said, speed limits? So, which is the only thing that makes me think about moving to Montana every once in a while. So, but yeah, that's one key way it does it. The other way that it can do it is so let's take, what's a business? We all know, what's it called? Classic Burger in Indian Current, right? You should all know Classic Burger. It's pretty much the best hamburgers around. The habit is coming in. I love the habit. I'll go to Classic Burger every time, right? And it shows that all of you do too, because whenever I go to the drive-thru, it takes 40 minutes to get my food because all of you think you need to eat. But at any rate, Classic Burger is regulated by both California and the federal government. Because under federalism, California has sovereignty, authority over all commerce within a state. Not between a state or between a state and a foreign power, but within a state. But under Article 1, Section 8 of the Constitution, the federal government has absolute authority to regulate all commerce between states. Got it? So far, so good? So Classic Burger, which is one locally owned restaurant, clearly in California, that uses local beef, by the way, which is one of the reasons why it's so good, because the same people who own Classic Burger own the butcher shop. So how is that interstate commerce? Well, in a ruling in the 1940s, the Supreme Court ruled that a farmer who refused to sell his grain on the market and used his grain only for his own family was still engaged in interstate commerce. Because if you refuse to engage in interstate commerce, you still affect interstate commerce by withholding goods from interstate commerce. And so anything that has any impact at all on interstate commerce, including not participating in it, is now considered interstate commerce and the federal government can regulate it. This is why we have both a federal minimum wage and a state minimum wage. So, and states have to have a minimum of the federal minimum wage, but they can go as far as they want. California's kind of taken that on steroids, which is like, we can raise it as high as we want, woohoo! Let's see if we can lose all minimum wage jobs. So, and now I have to order my food by some kiosk now. So annoying.
Tragedy.
It is a tragedy.
All right, let's move on.
There is a difference of freedom of speech and freedom to broadcast and market your speech on television, social media, and the internet. Or is there? What are your thoughts on what the Constitution protects or should protect?
All right, this impacts all of you, correct? So, have all of you seen this kind of, that it seems like more and more some very big corporations get to decide what is in the, what is being spoken about in the public square and what is not. And that seems pretty damn dangerous, correct? When you have people, especially when you have people like Zuckerberg deciding, because, he's kind of a numbnuts. And so, like, come on, dude, you're a billionaire. Don't wear hoodies all the time. You're not cool. So, but, like, or YouTube deciding what can go on there. Or with the Twitter files, Elon Musk takes over Twitter and releases all these internal files showing how they essentially throttled speech that they didn't like. And even more scary during COVID, showing how the White House and the Biden administration was pressuring Facebook and others to throttle information so that essentially, it's not that they banned it, but that when you posted it, they limited the number of people who would see it. So this is pretty scary. What can you do about it? Or can the Constitution do anything about it? So, can the Constitution do anything about the fact that a few companies, Google, Facebook, Twitter, right? Facebook is Meta and it does Instagram and the other. So, can essentially decide what speech gets seen a lot and what speech gets seen almost not at all. What can the Constitution do about this? Nothing. Nothing at all. Not a damn thing. The First Amendment gives you free speech against government coercion, government power. It does nothing against a private company or private property. Nothing. So, now that doesn't mean we can't do something about it. It just means the Constitution can't. I want to emphasize this. The Constitution isn't the document that exists to solve all of our problems. That is not the way that it works. Okay? And I get it. Sometimes we get very scared about this because we think, well, the Constitution, because Americans are theological. And we treat the Constitution like it is, revealed text, like it's scripture, And that's why we treat the Supreme Court justices as priests of Scripture. And so they have robes and they sit on the dais and they're up there and they're kind of like, we pronounce that segregation is wrong. We're like, yay! And the civil rights movement happens and we're like, justice has happened. The arc of history bends towards justice. That holiness has gone forward. And then the Supreme Court justices do something we don't like. Whatever that is for you. And I'll use a controversial example because I have tenure, so I don't care. But so whether that is Roe versus Wade or the repealing of Roe versus Wade, Roe versus Wade in the right side of the aisle goes, you heretics, you have clearly corrupted the Constitution. Repeal of Roe versus Wade, and the left side of the aisle goes, you heretics, you have clearly corrupted the Constitution. Guess what? Here's the truth. The Constitution says absolutely nothing about abortion one way or the other. And abortion absolutely is a political question, which is the one thing that the Constitution was not supposed to touch. Political questions. Those are democratic problems. We solve them through democracy. As a matter of fact, one of the primary consequences of Roe versus Wade, regardless of what you think about abortion, is that by taking it out of the realm of politics, we didn't talk to each other and try and persuade each other on abortion anymore. We just yelled at each other. Whereas if it was in politics for the last 50 years, we would have had to been talking this whole time and finding compromises. And we haven't been doing that. It's essentially become the lightning rod issue because all we've done is yell at each other for the last 50 years. So as the Supreme Court has pronounced from on high the holiness of abortion or the unholiness of abortion. It should have been a political issue the whole time. I get why people don't think it should be because it's involving the rights of people. Whether you're on the left and it's the rights of women or the right and it's the rights of the unborn, it seems like rights shouldn't be something that's political. But it is, because obviously the answer to that question depends on when we consider a nascent human life to become person with those rights attached. That's a political question. So nothing about free speech, but we can regulate them using the democratic process. Does that make sense? We just can't get the Constitution to come down and pronounce, Zuckerberg, you idiot, you can't stop this. We just have to go through and regulate it.
So yesterday we kind of talked, when we were talking about this, it kind of led us down the road of when does it become discriminatory to not share certain opinions on these platforms or certain freedoms of speech. And then we kind of went down the road of the cake maker and who you're allowed to refuse service to. How would you characterize the right of an individual to partake in this platform versus the ability and the ability to prevent discrimination from preventing?
This is the age-old question. This is the primary conflict between civil liberties and civil rights. Civil liberties is your right to self-ownership. Civil rights is your right to equal citizenship. So the classic case has become the Masterpiece Cake Shop case. The Colorado baker, who was very religious, didn't believe or believed that marriage was only between a man and a woman. And Craig and Mullins, a gay couple, went to Vermont, got married, came back, and they wanted to have a celebration of their gay marriage. And so they asked Jack Phillips, who was essentially, the most famous baker of wedding cakes in Denver at the time, to go, and they said, hey, we want you, and they had bought cakes from him before, and Jack Phillips knew they were gay, right? So it's not like he was like, whoa, wait a second. I thought you were just friends. No, it was obvious that they were gay. They weren't hiding it from anybody. And they asked him to bake a cake for their, essentially, celebration of their gay marriage. And Jack Phillips said, I can't do that. You can buy any cake off the stock shelf, but I can't make a cake specifically for you, because then I would be making a cake specifically to celebrate a marriage that I believe violates my core religious beliefs. And Craig and Mullins said, you're denying us service because we are gay, which is a violation of this 1964 Civil Rights Act and the Colorado State Civil Rights Act. You're violating our right to equal citizenship because you got a business license from Colorado, and when you sign the contract for that business license, you say you will serve all comers. You will serve the public. So that's one of the things you do in all states with a business license. You say, I agree to serve the public. Now, the public means that if you're open to the public, you're open to the public. Like, you don't get to say people with the light enough skin color is the public, and people with too dark of a skin color isn't the public, or people who are Christian is the public, and people who are Jewish or Muslim or Hindu or atheist are not the public. The public is everybody. But that only applies, the Supreme Court is slowly starting to come to this kind of thing, because when it did Masterpiece Cake Shop, it kind of avoided the question, and so now it's having to answer the question more and more. It avoided the question because Colorado's Civil Rights Commission is absolutely stupid, and they essentially called Jack Phillips a Nazi and said religion was evil and only used to oppress people. So they violated Jack Phillips's civil rights by essentially saying, because you're religious, we're going to enforce the law against you differently than we do anybody else. So they avoided the question of free speech of what you're asking, right? They're starting to now come to this situation of, if it is purely an economic transaction, then you have to serve all comers, okay? But if there's some form of artistry or speech involved, then the First Amendment might kick in. Because if Colorado forces Jack Phillips to bake a cake for the wedding, are they forcing him to support and to speak in support of something that he doesn't actually believe? The right of free speech is not only prevents government from stopping you from saying something, but it also prevents government from forcing you to confess something that you don't. That's called compelled speech. And since the First Amendment was, the Supreme Court first started ruling on the First Amendment, they said you cannot compel speech. You cannot compel your citizens to confess that they believe something they don't. Then we're back, then we're back in Stalin's Soviet Union and other things, right? So, but is baking a cake for somebody confessing that you support it? Well, this becomes the big question. Jack Phillips is saying, what's going to happen? They're going to get this cake. Well, where did you get this? Oh, you got it from the Masterpiece Cake Shop. Oh, wow, that's so wonderful. I'm so glad that somebody, that somebody supports these events. You can see how that works, right? Whereas the other side argues that you can say, this is just an economic transaction. You're a customer. I'm doing this way. However, so the Supreme Court is settling on this concept of if there's any sort of artistic initiative on the part of the business, then that they do not have to serve all customers in the same way. Just like you wouldn't want, because there's people are out there, right? You get the right thing and you're going to get some neo-Nazi skinhead group who's going to make sure they go to the kosher bakery and ask for a swastika cake. It's just going to happen. And so do you really want that to be the case? More importantly, you can understand that and by the way, there's a person by the name of, there's another lawyer by the name of Sardinia, who ever since the Masterpiece Cake Shop cake, he's been calling Jack Phillips and ordering the most extreme cakes possible and then suing Jack Phillips every time to try and get the court. So he's called up Jack Phillips and asked for a cake of essentially Satan with a gigantic penis raping somebody else, and he said no, and he sued him over that. So it's just like all of these things. And the thing is by Sardinia doing this, you're pointing out the Supreme Court's argument, right? You're trying to get Jack Phillips to do that because you're trying to make Jack Phillips uncomfortable by having to do something that violates his core religious beliefs, pointing out that baking a cake is symbolic. Therefore, it's covered under free speech. So, but if it comes down to the thing of like, ooh, here's the thing. Your melanin content is way too high. I think that I'm going to have to say no to you. You can't do that because it's just an economic transaction. And that comes from the 1964 Civil Rights Act, so you couldn't do the whole restaurant segregated thing.
We did get a question about this. What happens if I start a business without a license, when I don't agree with the government control? What am I dealing with now?
Right, so can you start a business without a license? No. I mean, literally no, you cannot. So the primary way this works is because if you start a business, you are inevitably expecting the government to protect your business. So that's one thing. The other thing is if you start a business where you're dealing with the public, then it's not just a private property anymore, it's a public property. So you are inviting the public in, you're now all of those rules of fraud, you can't say, I don't have a business license, so I can lie to you to get you to buy my product. Nope, the rules that apply to fraud still apply. Does that make sense? You're also using public ways. How are people going to get to your business? They're going to use roads and sidewalks funded by the local and state governments. So therefore, you need a business license because your license, you're hoping, probably, that a lot of people come there, which is going to put a strain on the roads, which is going to mean police officers are going to have to be there. So you have to have a business license. Every state requires you to have a business license. And if you do not, you get fined or put into prison. And I get it. I do have some libertarian leanings myself, which is kind of like, how dare you, you politicians? I'm smarter than you. I should be able to know what I'm going to do. And you kind of just want to resist. And you also get this kind of concept. Our forefathers shot the British in the face for just a slight increase in taxes. We should be able to, but no, you can't. Business licenses are impacts on the public. Therefore, the government gets to require you to have a business license. Fair enough?
All right, transitioning now into a couple questions about the Second Amendment.
Okay.
Given that the Second Amendment was written when it took roughly a minute to reload a gun, should the Second Amendment be updated to reflect the reality of today's assault rifles and automatic weapons?
This is a sensitive question because we're in Kern County. And so, because we're in Kern County, like half of all guns in California probably exist in this particular county. So, I think like gun ownership is kind of like tattoos, right? Once you get one, you have to have like 12. At any rate, unfortunately, I'm going to have to come down very specifically on one side of this issue. Now, I'm not saying anything about the morality or anything else of guns. This is only about the Second Amendment. Fair enough? Okay, good. Let's just be clear about that. So, there is this concept that the Second Amendment is outdated because of this exact reason, because they had essentially muskets that took a while to load and everything else like that. And therefore, the Second Amendment really doesn't apply to today. That has very little basis or backing in the history of the Second Amendment. The actual Second Amendment itself was championed by Thomas Jefferson, who is famous for the phrase that the tree of liberty must be refreshed from time to time with the blood of patriots and tyrants. Thomas Jefferson actually believed that once every 2 generations, every 40 years, there needed to be at least a little bit of a bloody revolution in order to keep the government in check and make them realize that the ultimate check on their authority was a violent revolution. So, obviously that's kind of easier to say, when you're a rich person on a plantation than when you're actually down there in the trenches, and he was the champion, and Madison, who wrote the Bill of Rights, including the Second Amendment, drawn off of because of Thomas Jefferson and the French kind of rights of man. All of those it was an individual right, drawn off of one of the most fundamental rights that goes all the way back to Aristotle, but really kind of captured by Thomas Hobbes, one of the most fundamental rights of all human beings, the right to self-defense. The right to self-defense. And the actual kind of philosophy behind the Second Amendment is you have a right to all the weapons in common use in any society. In other words, if it is most likely going to be used against you, then you're allowed to be able to use it to defend yourself from it. Does that make sense? And that is what the Supreme Court has ruled 3 times now, is that it's a right to self-defense. It is not a right to sport shooting. It is not a right to hunting. It is a right to self-defense. And actually what you see is the primary divide between pro-Second Amendment and anti-Second Amendment people is between cities and rural areas. Because if you live in San Francisco or LA or some sort of city, the police are like minutes or like a minute away. That makes sense? But you live in like rural Texas, the police are 15 minutes away. So obviously one of those, the idea of a Second Amendment or a right to self-defense becomes a lot more significant to you than another. Does that make sense? We also see it in terms of class. People in the upper class are much more anti-Second Amendment, and people in the lower class are much more pro-Second Amendment, right? People in the upper class can defend themselves by buying $1 million houses in good neighborhoods. Like my buddies all work for tech companies, and they live in Thousand Oaks, which is literally the safest city in the nation. So you can protect yourself by living in Thousand Oaks. Well, people in Compton can't do that. People in South Chicago can't do that. So there does become the politics of it become one way or the other. But it is an individual right. It was intended to be an individual right, and it was intended to be part of your self-ownership. Your self-ownership means you have the right to defend yourself against any weapon that is most likely going to be used against you. That's self-ownership.
And it also didn't delve into the idea of technology advancing, right? Like it didn't look back at the way technology had advanced from the time of catapults and slings and arrows and things like that. They were going to use whatever was available to them at the time, right? The technology at the time, and even as the rifle barrel and things like that advanced, there wasn't debates yet because we're still largely using these on the frontier, et cetera, out of daily necessity. So
right, actually, the scholar is like peering into the Second Amendment, and I have done this quite a bit. Just for reasons I don't need to go into. They're not like just fascination reasons. One of, when you get a PhD, you have specialties. I had 3 specialties. One of my specialties was constitutional politics. And the focus I did on constitutional politics was on, the Supreme Court and Constitution on religious, freedom of religion. And then secondarily was because the Supreme Court just started to take on the Second Amendment issues, there was a whole bunch of debates at USC about the Second Amendment issues. And so, and one of the things that it seems the most clear, what the Supreme Court is trying to say, is that the extent to which there's gun violence and gun ownership in a society is cultural, not legal. The law essentially follows after culture in this case. So we always kind of look at it and say, well, look at Australia. Australia banned guns and they got this big buyback program. But you actually look into Australia, and Australia's gun ownership was very restricted anyways, primarily to the outback, not to the cities, right? And so it was cultural. Is it a gun culture? Yes or no? If it's a gun culture, repealing the Second Amendment isn't really going to solve our gun problem. It's just not going to do it. But if you have literally an island nation, a continent nation, Australia is the only continent nation, right? The nation is the continent. Then all populated by essentially one group of people with not a whole lot of immigration up until the last 40 years, then and this massive amount of land without people being built all over each other all the time, you're just not going to have the same gun culture. And to the extent you do have a gun culture, it's going to be more of a rural kind of gun culture than it is because, a different. The United States, however, is a massive country with massive cities and the most immigration that any society has ever experienced in the history of the human race. And we've and not only so much immigration, I'm not blaming the immigrants, right? But saying that but it was very, very quick. We imported 1 million Irish in the span of 15 years. That's going to create ghettos. That's going to create cities with unequal and class divisions. That's going to create distrust, a breaking up of social capital by nature. It's not just that we've imported that we didn't import. It's not like we said, I'll sign up for 1 million Irish. But that we essentially just said, opened the doors and brought them in, but so quickly that it creates these divisions. And then we have a frontier culture, which means that guns were everywhere. If the history of the United States means that when you have more guns than people, you can't just repeal the Second Amendment and solve that.
Got a question from Zoom. Can you address why the term a well-regulated militia is in the Constitution?
Right, so, yes, this is the key thing. Why is it said for well-regulated militia, right? So, a lot of people think, oh, well, this must mean that it is not an individual right, but it is a right of the states against the federal government. Except for this, the only other place where it's given states' rights against the federal government is the 10th Amendment. Every other right is an individual right. So it's like the First Amendment, they're all individual rights. The states don't have a right to free speech, freedom of religion, freedom of association. The individuals do, right? The Third Amendment against quartering soldiers. The states don't have a right to have the soldiers quartered in their home. Individuals do. Fourth Amendment. It's not the states that have a right to prevent their property being searched without a warrant. Individuals do. And so we're carving out this little niche with the Second Amendment, ignoring the history of the right to bear arms in terms of the philosophy of England, France at the time. And then we're saying this one word militia means that it is a right of the states.
Are we binding ourselves to this because we actually took we have this setup for and other non-enumerated amendments, right, or non-bill of rights that we haven't spelled out, which means other things that we didn't think of, right, other amendments that we didn't think of. Because we chose to write down the Second Amendment, did that limit us and corner us in the language that we used in it?
Well, Madison thought the Bill of Rights was a terrible idea because he says, once you tell the government what it can't do, it thinks that it can do everything else but what it can't do, right? So for this example, I always use the example of when my wife and I the kids were old enough, we first were able to go out to dinner and leave them alone by themselves without having to pay for a babysitter. So my son was older, it was my son and my daughter, and we said, the only things, we essentially said, here's what you can't do. We're going to be gone for an hour. Here's what you can't do. Can't open the door, answer the phone, or leave the yard. We go out, we eat, we come back. My son's playing computer, my daughter's watching TV, and we're like, success. We're good parents. We don't need to call Super Nanny. So, and then 5 minutes later, somebody knocks on the door, it's our neighbor, and says, hey, just want to let you know, while you were gone, your son was skateboarding on your roof. And he's like, what? So I go ask my son, were you skateboarding on the roof? And he says, no. And I go, oh, okay. My wife, of course, is smarter than I am. And she kind of goes, wait a second. Were you on the roof? Oh, yes. Did you have your skateboard? Yes. Were you skateboarding on the roof? No. How is that possible? Well, because I was sitting on the skateboard. Skateboarding involves standing on it and pushing yourself. I was only sitting on it. Of course, my wife is furious, and I'm thinking, my son's going to be a lawyer. So, but that's the point, right? If you if you say no to these three things, a lawyer mind looks for all of the loopholes that it could try and get away with. Madison said, here's the only things we gave government to do. Article 1, Section 8 of the Constitution. It said, here's the enumerated powers. You can do this, and this, right? That's it. Nothing else can you do. And then he says, if you put in this Bill of Rights, they're going to say, now there's the space in between the enumerated powers and the Bill of Rights. That's the gray area, that we can do anything we want to. And that's, by the way, what states have done with regulating guns as well. The states have been lawyers. They're kind of like, okay, so we can't regulate guns, but Chicago, for example. All right, you can own a gun, but it has to be disassembled even when it's in your own house, and it has to be completely disassembled in order for you to own a gun, which of course completely invalidates the whole point of self-defense. And it's like, what? You have the right to gun ownership. The Second Amendment isn't the right to gun ownership. It's the right to effective self-defense, the right to bear arms. Right? Not the right to own something that is ineffective, but the right to bear arms. Now, the militia part comes in because the idea was, it says, we need to have all these citizens owning guns so that when in times of emergency we have to call up the militia, all they have to do is reach over, grab their gun, and be like the Minutemen. And come forward. But the key thing is, if you look at what a militia was back then, it was all private gun ownership. So even the militia part doesn't really get rid of private gun ownership.
Do we want to look at the second one on this or move past Second Amendment? There's a lot of the things we just covered.
Right, the balance to need to ensure public safety in a modern society. Oh, you know what, let's just do one more question. Let's do the diversity question because I want to get to
Okay.
Ed's question.
Last question. To what extent does the U.S. Constitution address the rights and needs of individuals who are deaf or hard of hearing, and how we can interpret its provisions in light of modern understandings of accessibility and inclusion?
Right, this is great. This came from Ed Kohlmeyer right there, the beloved Professor Kohlmeyer for a reason. So, it's a great question. And so we could take this as kind of this concept of people who fall outside of what most people would consider the normal range of what society looks like in some spectrum. Now, we all fall outside that range in some way, right? If you take society and you divide it up into enough axes, we fall on the outside in one of those ways. Does that make sense? Whether it's because of some sort of disability, because you're a racial or ethnic or cultural or religious minority in some way, because you happen to be the most handsome person in any room you're ever in, and that puts you on the far side of something. We all fall on the spectrum in some way. So, does the Constitution only protect people who are common on any sort of spectrum? Does it protect people who are the outliers, essentially? Obviously, people who are as hard of hearing, deaf or hard of hearing, or have these kind of disabilities, they are the outliers in this sense. And most of society is, of course, geared for the hearing, the people with sight, the people who don't have these disabilities. And so, how does the Constitution protect these people? Only in one way, and one way only, equal citizenship. And that's a very limited protection. The Constitution does not require any government to give any accommodation to any minority group, period. It doesn't. That is literally a political question, which is why we have the Americans with Disabilities Act. That requires us to put ramps in, to do all of these things. It requires me to put closed captioning in to all of my online
Legislation rather than Constitution.
Exactly. The Constitution, the only thing the Constitution does is say with the 14th Amendment that no matter who you are, you have an equal right to the protection of the laws, not that you have an equal right to all elements of society. That's a political question that we have to do through politics and the democratic process. We can't look to the Constitution for it. We have, and we've done it very significantly. Right, that's it. Thank you, everybody. Thank you
Thank
for
you very
listening
much.
to me.
Hope you enjoyed the constitutional discussion.
Thank you for the attention. I crave it.
All right. Just a couple announcements, guys, on your way out here today. First and foremost, be sure to stop by the library. There is a beautiful display there for Constitution Day and for voting. So stop by there, take a look at it. Right there at the entrance. You can't miss it. Also, be sure you have registered to vote. If you are registered, if you do the registration update, that will help the college in its endeavor to win the ballot bowl. Probably not going to win the ballot bowl, but we're going to try. So if you are registered, go get registered. If you are not registered, go get registered. We have links on the webpage, homepage, very, very bottom, and kind of scattered around throughout. And lastly, Kylie Town Hall is the first Tuesday of each month, and that is a gathering of the general student body. It's run by your student government here. If you have things you want to share about the college, issues that you're encountering, anything related to the student experience at Saracoso, you can bring that stuff to your student government. They are your representatives. So their job is to take your concerns to the respective committees on campus and try to do the good work to make the student life and student experience better here on campus. That's all I have. Thank you so much for coming to Constitution Day. We appreciate your attendance.